Mr Speaker.
I call Dennis O'Rourke.
Mr Speaker, New Zealand First still supports this bill, warts and all, but buying into it is a bit like buying a new car, especially if the old one has died and a new one is needed immediately. What one gets, one will be stuck with for a significant period in the future, whether it is fit for one's purposes or not. It would be good to have tested it properly before buying, and probably one should have been studying it months ago to see whether it would be fit for purpose, but that luxury has long gone. And so it is with this bill. Clearly, it should have been introduced months ago. The Minister said the process started in February. And for her, yes, I'm sure it did, but not for the rest of us, because for the rest of us, we've been given just a few days to look at this bill, to study it, to see its ramifications and to debate it. And that really isn't good enough. That's not the usual process which we have a right to expect in this Parliament for this kind of important legislation. So, Mr Speaker, New Zealand First deeply regrets that it is necessary at this stage to pass such a bill under urgency. And when you think about it, it's been almost a year since the Australians passed their legislation, and it's been 9 months since the process began in New Zealand to respond to that legislation. So in the end, we get this rushed process to pass a bill under urgency when in fact much better could have been done. And Mr Speaker, that rushed legislation shows, and it shows in many of the errors and the inadequacies in the drafting of this bill. Now, we in New Zealand First quite happy to acknowledge that the fundamentals of the bill are perfectly okay. We're quite happy to ensure that offenders are identified on arrival in New Zealand, and we're happy to ensure that prisoners returning to New Zealand comply with Parole Act conditions and any special conditions which may be imposed by the courts. So we have no difficulty with that, but Mr Speaker, it is the detail of the bill which has caused concern. And those matters, as we know, are usually sorted out in the Select Committee process, and that process is missing from this bill. And the most important aspect of that is that the public has no opportunity whatsoever for any input into this bill. And that is a very significant matter, because I would have looked forward to organisations such as the Law Society and many others who would have special expertise which they could have contributed to a much better piece of legislation. And we're not going to get that either, and that really is a shame. The only saving grace is Section 37, which requires a review and report by the Justice and Electoral Committee after 2 years. And the Minister's amendment says now that it should be an appropriate Select Committee after 18 months. But not even that is long enough in the circumstances. There were always two better options, and firstly, I think Labor's parallel process option is the one that ought to have been adopted, and that would have required effectively two bills, one passed now and the other to go through the Select Committee process in the normal way with full public consultation and so on. And that would have been the best of both worlds. We could have had legislation which could have been, as this bill will be, coming into force this week, and yet a Select Committee process to sort out all of the issues that there are with it. Now, I think that the only reason that the government isn't willing to do that is because to do so would mean that it would be admitting that it had acted too late. That's the reason why this government isn't willing to adopt that very sensible dual process which the Labor Party had proposed. The other option was a closer date for review than 18 months, because when you think about it, 18 months means at the earliest May 2017, and that's the time at which election issues are really starting to warm up, leading up to the election campaign for later that year. So effectively, it really means the review would actually be in 2018. And that's far too late. The opportunity to learn from experience after this bill is passed is the first year. So that really requires the review to start no later than 12 months from when this bill is passed this week. And that isn't being adopted, and that also is a shame, because to wait until 2018 for a complete review will mean that a lot of issues which will arise will go unfixed for far too long. So this could have been done a lot better, and New Zealand First deeply regrets that the government hasn't taken on board those concerns expressed by many of the opposition parties in Parliament. But, Mr Speaker, we already know of some of the areas needing review and which could have been amended right now and haven't been. Indeed, the Minister herself produced amendments within hours of the first reading of the bill. So she herself knew that she was bringing a bill to Parliament which actually needed amendment from the very beginning. Opposition parties have offered amendments in good faith to try to help improve the bill. A few have been accepted, but most have not been seriously considered, and that also is a shame. There was not the kind of opportunity, of course, that a select committee process would have provided for much better amendments and review of the bill. And Mr Speaker, actually when you consider it, this bill really could have been introduced by the government at least, say, 6 weeks ago, because it has had at least 9 months, if not more, to bring the bill to Parliament. If it had done so 6 weeks ago, we could still then have had a shortened but worthwhile select committee process with public submissions, and especially submissions by expert organisations, and the result right now, this week, would have been much better legislation. Now, Mr Speaker, I want to acknowledge David Parker and Trevor Mallard in particular, who raised drafting issues and issues of substance and placed them on the record, and they have not been dealt with and ought to be. It should not be necessary to wait until 2018 effectively for those matters to be looked at again. David Parker in particular offered an SOP which I thought was well worthwhile, to add words to clause 9, to add a requirement for offenders, as they are so called in the bill, to provide information about convictions and penalties. That information is obviously necessary. Why has it been left out? It would have been so simple to add those few words to the bill, completely harmless words, completely worthwhile words, which would have added some important information, but the government has refused to do it, with some pretty weak excuses made by the Minister, I would have to say, excuses which didn't really make any sense. So the bill will now be passed without those words added, and it will be the poorer for it. I raised a number of issues regarding clause 7, especially around the term, quote, liable for deportation, unquote. Those also have not been addressed. I raised issues about clause 10.2 concerning the period of detention. The Minister said case law could be relied on to define what is a reasonable period, but why not specify a maximum reasonable period in the bill? That would have been better. So the Minister's response, I think, was completely inadequate on that. And Mr Speaker, I and others have raised a whole raft of other issues, issues of substance, issues of drafting, and all of those will now have to wait effectively until 2018 before anything can be done about them. And really that's not good enough for a process for legislation of this important. And finally, Mr Speaker, let me say this. New Zealand First has always supported the objects of this bill, the object of making sure that we are ready to accept a greatly increased load of offenders and returning prisoners, especially those from Australia, but also from other countries as well. We have always accepted the need for that. It's probably legislation that should have been done years ago, so we've been happy to see this legislation come forward. We support it. What we do regret very deeply and we protest about very strongly is that it has been so slow, and the opportunity for opposition parties and indeed the public to have genuine and substantive input into this bill has been completely inadequate.
I call John O'Naylor.